Thank you. Thank you, everyone, for joining us today, virtually as well as in person at Fordham Law School. We are delighted to host today's event. I'm president of Fordham International Law Association. I will be moderating today our distinguished panel of judges, former cabinet ministers, and leading activists from around the world joining us today to discuss how to combat grand corruption, including by creating an International Anti-Corruption Court, or IACC. Before I introduce each panelist, I'm pleased to introduce Senior U.S. District Judge Mark Wolf, Chair of Integrity Initiatives International, which is the leading coordinator of the global campaign for an IACC, to give a few opening remarks, and then I will move to introduce the rest of our distinguished panelists. Thank you very much, Judge Wolf, to be present today.
Thank you, Tina. I am Mark Wolf. I'm a senior United States District Judge, a federal trial judge in Boston, and the chair of Integrity Initiatives International, III, as we call it. The mission of Integrity Initiatives International is to strengthen the enforcement of criminal laws against kleptocrats, who are also the worst abusers of human rights. The genesis of III is, in my experience over the decades as an assistant to the Attorney General of the United States after our Watergate scandal, when President Nixon resigned because of compelling evidence, much recorded by him, of crimes he was committing in the Oval Office as a federal prosecutor of corrupt public officials in Massachusetts before becoming a federal judge in 1985. And in presiding in cases, including one in which I sentenced the Speaker of our House of Representatives, our Parliament, to 8 years in prison for taking bribes. And as I was going around the world, frequently, almost always at the invitation of American ambassadors, I was in Egypt and Turkey and the Czech Republic, Slovakia, Romania, Russia, and China. I was very struck by the fact that the countries I was visiting were all led by kleptocrats, corrupt leaders who were among the worst abusers in the world of human rights, and who had impunity in their own countries because while they were members of the UN Convention Against Corruption and all had laws making bribery, misappropriation of public resources, embezzlement, money laundering illegal, they had impunity in their own countries because they controlled the police, the prosecutors, and the courts, which sadly were often corrupt on their own. So III was founded with the mission of strengthening enforcement of criminal laws against kleptocrats and those enablers, private individuals who conspire with them, including to launder their illicit fortunes. Our activities have several prongs. We work to strengthen the capacity of nations to combat corruption themselves. We've done that most prominently in Ukraine, where I was involved in helping get the legislation to create their National High Anti-Corruption Court, in the process of selecting judges and mentoring them. I was scheduled to have 5 high anti-corruption court judges with me in Boston earlier this month, but sadly, again, they couldn't leave. We worked to promote greater collaboration between human rights organizations and anti-corruption organizations. And very importantly, it's always been a purpose of III to forge a network of networks of courageous young youth activists, anti-corruption activists from around the world. Tina personifies the now more than 60 people actively member of that network. And we're best known for our catalyzing and coordinating a campaign to create an international anti-corruption court, which I expect will be discussed today, to hold kleptocrats and their enablers accountable if they are from countries that are unable, such as Russia, or unwilling, such as, unwilling, such as Russia, with regard to Putin, or unable, such as Moldova, which has an honest president, but doesn't have the capacity now to prosecute those officials themselves. I can't tell you how gratifying it is to be on a program at which the International Anti-Corruption Court will be discussed, where I'm not one of the main speakers. I've done probably hundreds of programs since I first proposed the International Anti-Corruption Court in a pair of articles in 2014. And for a long time, as this concept became known around the world, before it really became a campaign about 3 years ago, I think it was regarded by many as the idiosyncratic idea of some quixotic judge from Boston. But today, Tina, as I said, a leader of the International Youth Leaders Network of III, has put together this program. We have my friend and colleague, he'll get introduced with all his impressive credentials. Allan Rock speaking, Judge Maria Wilson from Trinidad, Tobago. Nobody should think that a country as small as Trinidad, Tobago is not vitally important. It's actually the country that first proposed the International Criminal Court, as I understand it. I met Sid 10 years ago when he was at Harvard Law School, and two of my interns for life, Christina Migiani and Colette van der Ven, are now doing impressive work, which started working with Sid. Michel, whom I've never met before, but feel like I have because he's a legend for his extraordinary writing and advocacy concerning corruption, and Evan Mawarire, who from Zimbabwe, who I only met a month ago, and about a month from now will be elected proudly by us as a director of III. So, as I say, it's extraordinarily gratifying that each of the people I mentioned share my passion for combating grand corruption and bringing their extraordinary talents and experience to the endeavor, and also very gratifying that we can have this program here at Fordham Law School, because the Youth Leaders Network has always been regarded as vitally important by me. Young people, in contrast to their elders around the world, are not cynical about whether anything can be done about corruption. It's part of the lived experience of many of them. I've been talking with people from Georgia, Ukraine, Nigeria today, part of their lived experience. And young people are doing things around the world that their elders frequently think were impossible. So, Tina, I thank you and your colleagues for organizing this program and for giving me the opportunity on short notice to make these remarks.
Thank you. Thank you very much, Judge Wolf. We really appreciate your presence here and support that you've given to Young Leaders Network, which I represent now today. In addition to my being a president at Fordham International Association, who is proudly co-hosting today's event. I'm now very pleased to introduce Ivan Mawarire, a Zimbabwean activist and pastor who bravely stood up against authoritarianism in his country at great personal cost. He's now the director of the Frontlines of Freedom at the Renewed Democracy Initiative, where he shines a light on the stories of activists like him around the world. Ivan, it's over you. Thank you.
Thank you so much, Tina, for that wonderful introduction. It's such a huge honor for me to be part of this presentation today. I hold in high regards many of the people who I see here, some whom I've only known by name and from afar, but some who have become very good friends of mine, including Judge Wolf, as well. I want to just thank you for committing your lives, your time, and your expertise towards this incredibly important aspect of helping nations and people from nations like mine, Zimbabwe. I now live in exile in the United States because of the work that I began in Zimbabwe as a private citizen to help to curb the effects of corruption. In 2016, April, I uploaded a video on Facebook bemoaning the levels of corruption, injustice, and poverty that Zimbabwe was going through. If you followed Zimbabwe over the years, you will know how deeply affected we'd been by those issues. At the time, the Robert Mugabe, who was president of Zimbabwe since 1980, was still in power, had been in power for 36 years. And in 2016, at that time, when he'd been in power for 36 years, I recorded this video to say we cannot accept this level of blatant corruption, this destruction of our nation to happen as citizens and do nothing about it. The institutions that have been built to do something about it have failed. At one point, I remember the president announcing publicly that $15 billion worth of diamond revenue went missing from the treasury in Zimbabwe. $15 billion. This is a country whose the size of our economy at the time and even now was only $4 billion. So $15 billion represents a world of change for a country that is still struggling with diseases such as cholera and typhoid, in our midst. So I put up this video saying to the citizens, we've got to do something about it. In 2008, Zimbabwe had been through an economic disaster where our inflation ran at 286 million%. Yeah, you heard that right, 286 million%. That was the rate of inflation. We landed up with one of the largest banknotes ever printed in the world, which was a $100 trillion note, 100 and then 12 zeros after that. And I remember trying to buy a loaf of bread with that note. And when it was my turn to buy the bread, I could only get half of the loaf with $100 trillion. So this was a dire situation. And we were there because our leaders and those connected to them had created a cartel that enriched itself off the back of Zimbabweans, off the national resources, of our country. And by then we had no service delivery. We had no more access to decent education, no more access to health delivery, no more access to a justice system that worked. It was compromised. The judiciary was captured. We had a destroyed economic system. And of course, our democracy was destroyed. And so we began to mobilize people to understand the effects of corruption on our country. But sadly, what we did not have and still do not have access to is how is justice served when things like this have happened. We mobilized over 12 million people, and I still don't know how we did it. I thank God that I'm still alive and that I have been able to live to tell the story. But I pastored a church of 35 people, and over 3 months, we were able to mobilize 12 million people to say enough is enough, because we had lost everything once before, and we were losing it again in 2016 due to corruption. Once we mobilized the 12 billion people, I was promptly arrested. I was charged with attempting to overthrow the government, which was a lie. I was held in a maximum security prison, had no access to justice, at the time, and eventually was released because people began to protest my arrest. Once in safety here in the United States, it was not enough for one man to escape and think that that solves the problems. And so what I decided to do was to leave my family here in safety in the United States and to go back to Zimbabwe to continue the work. I was arrested immediately on arrival at the airport. I was thrown into Chikurubi maximum security prison, where I was held for 3 months. but we continue to organize even from prison, and spent that whole year organizing more protests, more campaigns for ordinary people to understand the effects of corruption. Eventually, Robert Mugabe stepped down after we mobilized enough people demanding him to leave office because of the levels of corruption and poverty in Zimbabwe. Sadly, a new regime took over, which was the second tier of Robert Mugabe's oligarchs and people that benefited from the feeding trough of corruption. They then took over and, of course, continued the very same brutality that we thought we had undone. So I want to thank you for this opportunity to give you my lived experience and lived reality with corruption. I had no access to justice whilst I was in the maximum security prison. I was abused in so many ways. I was tortured in ways I still cannot talk about publicly. And it was all because a system was corrupt, a system was captured, and these people were not able to be held accountable, even as we tried by their own citizens. And as I look back on Zimbabwe and even now where the nation is, the hope is that there is a system that can be developed that is outside Zimbabwe, that takes care of the crimes that these people have committed whilst they were in office or continue to commit today. Part of the crime is that a lot of the resource, if in fact all of the resource that is stolen from our nations, is stored outside Zimbabwe. In free nations, they use the systems of free nations to store their wealth, and they come and enjoy their wealth in these nations, whilst the people that they have stolen that money from live in abject poverty and without access to the basics that they should have. So I come to you with this lived reality. I come to you with a sense of gratitude that you are putting your heads and hearts together to try and understand how this can be addressed, because it needs to be addressed. People live without dignity. The only thing that Zimbabweans want is not power themselves. It is not wealth beyond anything else. It is the dignity to live decent lives and the opportunity to leave a legacy of inheritance for their children that they can be proud of. So thank you for having me. Thank you for allowing me to be part of the conversation and to make these submissions. I hope to learn a lot from you all during this process, and I hope that my experiences will also be able to contribute towards some of the learnings that we will have here today. Thank you so much again for the opportunity.
Thank you very much, Ivan, for sharing this inspiring story. It's always very important to recall that it is lived experiences, and you are you are a true inspiration for everyone now here attending and also speaking. And thank you for your time. Now I will turn to Michel, the director of the Combating Kleptocracy program at the Human Rights Foundation. Kezi has written an excellent book, American Kleptocracy, which illustrates how the United States jurisdiction fuels grand corruption globally and how intertwined American lawyers, bankers, real estate agents, and other so-called professional enablers are in the transactional networks that launder the proceeds of corruption. Kezi, why did the Human Rights Foundation launch a program on kleptocracy on a first hand, and how should we understand the relationship between corruption and human rights?
Sure, Tigger, great question. Thank you so much for having me today. Judge, thank you so much for not only your kind words, but everything you've done. Talk about a legend that I'm sitting next to. And I should say before anything, Evan, I had a chance to see you speak a month ago. Oh, do I need to use the mic? Yes. I had a chance to see Evan speak about a month ago, and when I saw I was following him today, I had my heart in my throat because I knew I would not match up. What an impassioned speaker. Evan, it is an honor to listen to you anytime, and I apologize to everyone for having followed that. So, Tiki, your question is, why did Human Rights Foundation start this program? And it's a good question, because the organization that I work for, Human Rights Foundation, has one specific mission focus, and that is dictatorships and authoritarian regimes. That is what this organization, which was founded in the mid-2000s, focuses on. The threats of these dictatorships, especially to those domestic audiences, in places like North Korea, in places like Russia, in places like China, in places like Turkmenistan, Gabon, and Egypt, and the UAE, and Venezuela, and Cuba. And they have done phenomenal work, and they have done it for years. And then toward the kind of late 2010s, early 2020s, there was this burgeoning realization, which I'm sure you picked up on this in your work as well, that as Evan was just talking about, these dictatorships, these authoritarians, yes, they are all corrupt. Yes, they are all kleptocratic. Yes, they exist for themselves, for their family members, for their inner circles, to enrich themselves and to immiserate their entire nations. And we have seen this for year after year, decade after decade. Doesn't matter if they are nominal communists in Pyongyang. It doesn't matter if they are hard right authoritarians, increasingly in places like India or Hungary. It doesn't matter the kind of ideology underpinning them, because at the end of the day, they are dedicated toward enriching themselves. And yet that money that they are stealing, the $15 billion that Evan just mentioned out of the Zimbabwean diamond mining industry alone, which is a drop in the bucket of global illicit wealth, that money does not stay there, does not stay in Nigeria, does not stay in Russia, does not stay in Zimbabwe, does not stay in these countries. That corruption, just like increasingly we have seen the authoritarianism itself, does not remain limited to that nation. Instead, it crosses borders. It crosses hemispheres. It crosses jurisdictions. And all too often, again, as Evan mentioned, and as plenty of others have talked about, I'm sure today, as well as in plenty of other research and publications elsewhere, that money comes to places like the United States of America. And as you may be able to tell from my extremely thick American accent, this is where I'm from. This is where I live. This is where I work. This is what I focus on. Much of my work is on the United States of America's transformation into the world's leading offshore and financial secrecy pro-kleptocracy jurisdiction. Because that word is a mouthful. The title of what I actually do is a mouthful. I trip up on it off. Combating kleptocracy. That word literally means rule of thieves. So when we're talking about Putin or Erdogan or Xi or whomever it may be, whichever regime it may be, those are, of course, kleptocrats, and they oversee kleptocratic regimes. But in the 21st century, modern kleptocracy is international. Modern kleptocracy is global. So when we're talking about combating kleptocracy, we're not talking about just combating one regime over there. We're talking about a global phenomenon in which, according to the best estimates, trillions of dollars are swirling around the world, illicitly gained, stolen from populations elsewhere, and moved into third-party other jurisdictions to be hidden, to be laundered, to be stripped of any identifying information, but still enjoyed by those regimes, by those leaders, their family members, their hangers-on who all want to live like a celebrity and remain in power as long as they can. And unfortunately, this is a global phenomenon. Again, much of what I do is in the United States of America, looking at what the U.S. has done, the policies, the loopholes, and certainly I'm happy to talk about more of that, how the American shell company industry and entire states like Delaware and Nevada and Wyoming, which I'm fortunate that I've been to all three. A lot of folks haven't. They're all very lovely in their own way, but they're effectively captured by the shell company industries that provide the anonymity that these regimes and these oligarchs and these kleptocrats all need to, again, strip identifying information from where that money is coming from and where that money is going, to make it impossible to identify, to track and trace where that money is going to. Has anyone been to South Dakota? No? Anyone up there? No. It's beautiful. It's fine. Yeah. But it's wonderful people in South Dakota. What a lot of folks haven't realized, and again, this is late 2010s, early 2020s, where this is really kind of coming into being into the fore, is that South Dakota is now the new, arguably, global center of offshore finance. It has this thing called the trust industry. Effectively, what it allows people to do is bring their money into South Dakota. They never have to go there. but they can protect that money in perpetuity. They never have to give that money up. They never have to share information about that money with any other government whatsoever. And we're talking about an estimate, at least hundreds of billions of dollars right now, stampeding into South Dakota, of all places. It's not Switzerland. It's not the British Virgin Islands. It's this flyover state in the middle of America. Anyways, this is the United States of America. This has also been taking place in Canada. This has also been taking place in the EU. This has also been taking place in Australia and New Zealand, across the democratic world, opening up our doors to all of this illicit wealth. And again, these are, as you said, Judge, the worst humans on earth. These are the world's worst abusers, narco traffickers, arms traffickers, kleptocrats, dictators, taking their money and plowing it into places like the United States of America, like the New York real estate industry, like the Connecticut private equity industry, like London accounting, like French real estate, like Australia's beachfront properties, over and over and over again. So that's the problem. And again, we're talking about trillions of dollars. There is some good news, because I like to have a little bit of optimism. We are making progress. We have seen transparency requirements and reforms in the American shell company sector. The current administration has said, hey, real estate, hey, private equity, those decades-long loopholes that you've enjoyed, pulling in trillions, estimates of trillions of dollars in illicit wealth, those are going to be no more. And look, this is good news. But this is just one step forward. I mean, I would love to not have, well, I'd love not to have this job. I need a job, I have mouths to feed. But the problem we know about, the solutions we also know about. It's a matter of having the political capital, the kind of alliances and networks to get there. Look, as you can tell, I can ramble on and on and on for however long you want me to about this. There are solutions. It's just a matter of getting there. I'm happy to share more stories. They're not all horribly depressing, like some of the ones I've talked about. Because you got to have fun with it. Otherwise, you're just going to cry the entire time. But I guess I'll stop there and take it.
It can be saved to you.
I'll keep this.
Yes, you can keep it. Thank you very much, Kazai. It's very important to know that, yes, there is solutions, and this panel is all about finding those solutions. And there is already in place the creation of Global Anti-Corruption Court, which all of us support and think that it might be a solution to all of these difficult and like brutal crimes in different countries, not limited to any particular. So what can be done on national level? This is something that I will ask to our next speaker, Sid Butuyan, who is currently Director and Chief Ethics Officer at UNICEF in New York. But today he will be speaking in his personal capacity. I wanted to note that. Prior to the UN, Sid spent over 15 years at the World Bank in its Washington headquarters, where he led global anti-corruption investigations. He taught a course on transnational corruption at Harvard Law School for several years and currently teaches international relations at Sciences Po in France, where he is now, and he's joining from Paris. He served multiple terms as co-chair of the American Bar Association International Criminal Justice Committee. Sid also served in his home country, the Philippines, as the inaugural antitrust commissioner, and he was an impeachment prosecutor in the historic first impeachment for plunder and grand corruption against the sitting Philippine president. I can think of no one better situated to share with us what opportunities there are to combat corruption at the national level and what conditions are required to do so. Sid, if you're here.
Thank you, Tina. Can you hear me okay?
We can hear you perfectly. Thank you.
Yeah. First of all, thank you for the host organizations for the invitation to participate in these very important discussions. And Tina, you asked so many important questions, and I'm afraid we would need an entire summer course to cover all those topics. So let me just sketch some relevant ideas in the limited 10 minutes that I have. But before proceeding, as you noted, Tina, the views I express are solely my own and should not be associated with my benevolent employers, past or present. As mentioned by Judge Wolf, it's been a decade since I started teaching a course on transnational corruption. Back in 2014, Judge Wolf spoke at Harvard Law School and engaged with my students on his exciting proposal for the establishment of an international anti-corruption court. I am delighted to see the great progress achieved since, including the recent formation of a treaty drafting committee. It's an incredibly powerful development, and I'm eager to be involved in the discussions. I also note with delight that the declaration of the proposed IACC has the following important text, and I quote, "The IACC should have, in civil as well as criminal cases, the authority to recover, repatriate, and repurpose illicit assets for the victims of grand corruption." This underscores the importance of ensuring that victims receive due compensation for harm. This is very promising indeed. I have frequently spoken about what I call the missing victim problem in previous anti-corruption approaches. So in 2014, the students in my class brainstormed various proposals and even drafted a model statute for a prospective international anti-corruption court. Initially, the students leaned towards a more restrained approach, advocating for the creation of a civil court specifically geared towards the recovery of assets. They explored the idea of integrating an optional protocol for an international anti-corruption court as an annex to the UN Convention Against Corruption, or UNCAC. The UNCAC leaves open the possibility for a court to be established within its framework by allowing for the creation, and I quote, "of any appropriate mechanism or body to assist in the effective implementation of the convention." Essentially, the initiative proposed by the students would provide the UNCAC with the enforcement capabilities it currently lacks. But by whichever modality the international court is to be established, and I'm eager to hear the proposals, let me highlight in any case the critical importance of adopting a victim-centered approach in the ongoing project. You see, we often hear that corruption kills, but sadly, the victims of corruption are often overlooked in our current legal frameworks, thus the missing victim problem. And Evan's powerful testimony just a moment ago of his lived experience is a testament to this gap. Over the past decade, there has been a proliferation of rulemaking on what constitutes corruption-related misconduct and what the appropriate penalties are. But deep ambiguity and confusion persists about the harms caused by corruption and what remedies are appropriate. These shortcomings are evident both in legal literature and anti-corruption strategies. The UNCAC established an international framework obliging state parties to afford victims of corruption the right to initiate legal proceedings. Article 35 of the said convention calls on states to take measures, and I quote, "to ensure that entities or persons who have suffered damage as a result of an act of corruption have the right to initiate legal proceedings against those responsible for that damage in order to obtain compensation." But sadly, UNCAC has its limits. A study conducted at Harvard Law School revealed that the implementation of the UNCAC provision on civil remedies has been inconsistent, as many state parties failed to create a private right of action for victims. This is no surprise, given that the provision on victim compensation under UNCAC are not self-executing, requiring the passage of enabling local legislation. At the national level, as you mentioned, Tina, the focus of national anti-corruption legislation has been on the perpetrators rather than the victims, on the crime rather than the harm, and on penalties rather than remedies. For instance, the US FCPA and the UK Bribery Acts and many other national legislations embody a prosecutorial strategy rather than a restorative approach. They do not and are not designed to provide relief to citizens of endemically corrupt countries. In addition, Different jurisdictions have different rules for determining who may be considered a victim of corruption especially in situations where harm is indirect and spread across numerous claimants. Moreover, many countries lack a robust framework for public interest litigation. As a result, the pursuit against corrupt actors has been left mostly to public authorities, with private parties assuming passive roles as notable surge in anti-corruption civil lawsuits globally. This aligns with the growing acknowledgement that corruption does cause harm and is not a victimless crime. The recognition that corruption inflicts public harm has been groundbreaking, highlighting that the public is the crucial stakeholder in combating corruption. For instance, the UN Anti-Corruption Toolkit advocates for a strategy that involves individuals to report corruption incidents, motivating them to raise concerns about poor public services linked to corruption. Recent anti-corruption strategies also now advocate for whistleblowing protection laws and safeguards for victims and witnesses. Interestingly, experts have looked into using international human rights law to compensate victims. A study by TI, or Transparency International, showed how corruption can violate human rights. This approach views corruption as a human rights violation, aiming to protect and compensate those affected, particularly citizens living under corrupt regimes. This approach, of course, is very widely contested, and I wouldn't have time to delve into the details. Lastly, those who have been watching the International Criminal Court, or the ICC cases, especially recent cases involving reparation of victims and the establishment of trust fund for victims, are also, significant signs of progress in this field, although it is still quite limited and has its unique challenges. So let me wrap up very quickly. The significant harm by corruption, especially to the poor, demands attention from policymakers and diplomats as an urgent global justice issue. In the words of former UN Secretary General Kofi Annan, corruption undermines democracy and the rule of law, leads to violation of human rights, and hurts the poor disproportionately. Various studies have shown this as well. Indeed, the silence of corruption victims is a long-standing injustice we must correct. That is why the IACC declaration, which highlights the importance of compensating victims of corruption, is a big step forward in this direction. You see, putting victims at the center of any anti-corruption project can result in a virtuous circle of reinforcing effects. Victim-initiated legal actions have the potential to supplement severely under-resourced enforcement agencies, enhance detection, heighten deterrence, and strengthen the legitimacy of various anti-corruption measures. In closing, let me reiterate that I look forward to the continuing collaboration in helping ensure that anti-corruption projects like the proposed IACC deal equally with perpetrators and victims, embody punitive and restorative approaches, and adopt a more holistic conception of justice that focuses beyond retribution towards restoration and reparation. Thank you for your attention. Over to you, Tina.
Thank you very much, Said. We really appreciate your balancing approach to find a solution. And I think it is clear that there are many important anti-corruption ideas that will need to work together in order to address this global issue. To better understand one of those pieces of puzzle, we will now turn to Justice Maria Wilson to learn more about the IACC idea. Justice Wilson is a Justice of Appeal of the Supreme Court of Trinidad and Tobago, Prior to her role on the bench, she was a trial lawyer at the International Criminal Court and International Criminal Tribunal for Rwanda, and a former assistant director of public prosecution in Trinidad and Tobago. She is now a member of the expert group working on the draft IACC treaty. Justice Wilson, we are honored to have you joining us today, and we would love to hear you introduce for us the proposal for an IACC. Thank you.
Thank you very much. I'm very pleased to participate in this panel discussion, and I thank the organizers for inviting me here today. I feel very passionate about the formation of an international anti-corruption court because I feel it's critical to fill a crucial gap in the international framework for combating grand corruption. I support its creation for the following reasons. According to the Transparency International, the Corruption Perceptions Index for 2023 revealed that corruption is thriving across the world. TI ranked 180 countries and territories around the globe by their perceived levels of public sector corruption, scoring on a scale of 0, highly corrupt, to 100, very clean. They found that 2/3 of countries scored below 50 out of 100, indicating that these countries have serious corruption problems. The global average was at only 43, with the vast majority of countries making no progress or declining in the last decade. Additionally, 23 countries fell to their lowest scores to date in 2023. We need to view such dismal numbers against the backdrop of there being some 190 countries as of October 2023 that are party to the United Nations Convention Against Corruption, each having laws criminalizing corrupt conduct. But this has not stopped the prevalence of corruption in each of these countries, in most of these countries. We therefore recognize that corruption continues to exist in many countries, despite the fact that there are national laws that provide sanctions for the commission of such corruption offenses. It is pellucid that the problem is not lack of laws, but lack of enforcement of those laws at the domestic level. This lack of enforcement results in impunity for corrupt individuals, including national leaders who use their public power for private gain. This results in many negative consequences for citizens of such countries. On a national level, this results, amongst other things, to diversion of resources from developmental goals, the undermining of public trust and confidence in the government of such countries. It impacts negatively on foreign investments. It creates social division in such a country. It sometimes results in political instability and unrest, and impacts on the rule of law and erodes democracies in such countries. Rather than that country being based on the rule of law, the country instead is based on the will of corrupt leaders who feel empowered to influence different sectors of the administration of justice, including investigators, police, customs officers, and even judicial officers. It can lead to loss of confidence of citizens in the administration of justice, erosion of human rights, migration of honest businessmen and citizens to other countries, amongst other things. So that's on the national level. And on the international level, any attempts of the international community to resolve global issues, such as global climate change, the COVID pandemic, attaining the UN sustainable goals, for example, would require monies to be donated to or given to such countries. And there's always the risk of corrupt leaders using such money for their own personal gain. So we believe that the creation of an IACC, through that, some corrupt national leaders and their enablers will be held accountable for such crimes. So you've heard from Judge Wolf that the III, they're the driving force of this idea of creating an international anti-corruption court. And just to give you a brief summary of what has happened to date. So in 2022, 3 committees were formed. The Treaty Committee, composed of international judges and international prosecutors and other leading experts in international law. And this committee is working on core principles for drafting an international anti-corruption court treaty. That treaty, the Treaty Committee, benefits from the work of subcommittees as well. There are subcommittees such as one dealing with core crimes, court management, asset freezing, jurisdiction, international cooperation. I'm in fact a member of the Treaty Committee and of the subcommittee on whistleblowers and victims. So with the support of the drafting committee, the Treaty Committee would then produce a draft treaty for consideration by interested governments and for consultation from civil society. The treaty drafting process will then further benefit from feedback from an advisory committee composed of international lawyers and scholars. So meetings for these committees and subcommittees usually took place virtually. However, last year, through the generosity of the new institute in Hamburg, we were able to have the first in-person meeting with members of the Treaty Committee, and that took place over some 10 days. Additionally, earlier this month, there was a second in-person meeting of the persons who chaired such subcommittees, again at the new institute in Hamburg. And we expect to have a third such in-person meeting in Hamburg at the latter part of August to drill down further on pertinent issues which we're discussing. That will take place over a 10-day period as well. So you'll immediately realize that this is a work in progress. And one person who participated in the meeting in April had this to say about it. She said the meeting in April was extraordinarily successful, productive, with substantial progress made across various subcommittees. So the aim would be to draft, continue the drafting over the next 3 months and to discuss the first provisional draft in the August meeting, and to aim at having a draft by the end of December 2024, so that we can then get some input from civil society and other governments interested in supporting this initiative. So you might be wondering, what is this IACC going to look like? I'll just give you little snippets. Firstly, we envisage a court, an international court with 2 chambers, a criminal chamber and a civil chamber. In relation to the criminal jurisdiction of the court, this international court will be a court of last resort, that is only if national courts are unwilling and unable to investigate and prosecute corruption crimes, that the IACC will investigate and prosecute such crimes. We have adopted this concept from the Rome Statute, which is the treaty guiding for the ICC. And we believe that this is the right thing to do because it's the primary responsibility of nations for them to investigate and prosecute their own offenses. So the IACC will complement national jurisdictions rather than assume their primary role to investigate and prosecute such offenses. This preserves the sovereignty of nations and also recognizes the international nature of corruption. That is, that the ill-gotten gains are often placed in overseas banks and invested in properties and shell companies abroad, and that corruption can ultimately impact on international peace and security. We have decided that the core crimes within the jurisdiction of the court will be corruption offenses, which are mandatory for state parties to the UNCAC to criminalize. These are referred to in Chapter 3 and include bribery of national public officials, bribery of foreign public officials and officials of international organizations, embezzlement, misappropriation, money laundering, obstruction of justice. These are just some of the few mandatory crimes. And we have agreed to such mandatory crimes because we think that it can be readily justified as being part of our core offenses because it has the sanction of so many other international state parties. We will continue to discuss whether other crimes should also be included. The second aspect of this IACC is that it will investigate and prosecute nationals of foreign states who commit offenses within the jurisdiction of the court in the territory of a state party that refers that investigation to the court. So one of the many questions which I have been asked is, why would corrupt leaders want to be a state party to such a treaty? The goal is to attract as many member states as possible. However, we do not necessarily need all countries. What we do need to be part of it. The ICC will have a jurisdiction to prosecute nationals of member states, and as I've stated a while ago, foreign nationals who commit all or part of a crime in the territory of a member state. The IACC could therefore be effective with a small number of states, so long as the membership includes states with key financial centers and other countries that kleptocrats use to launder the proceeds of their crime. Another aim of the IACC is to provide a forum to fairly and effectively investigate and prosecute kleptocrats and their transnational enablers. That would include lawyers, bankers, accountants, real estate agents, and service providers. Thus, we'll continue to analyze the core crimes within the jurisdiction of the court to determine whether such crimes are the ones likely to be committed by kleptocrats and their enablers. The IACC will also be instrumental in deterring future grand corruption by establishing a credible threat of investigation and prosecution where such a threat does not currently exist for kleptocrats and their co-conspirators. You will readily agree that an efficient and effective criminal justice system, is necessary for a court to be a deterrent to the commission of crimes under its jurisdiction. That's a normal thing in any national jurisdiction. And we believe that this also applies equally to the International Anti-Corruption Court. Our aim is to create an effective and efficient court. And we have considered other international courts to see what lessons we can learn from them and how we can create such a court so that it will be a deterrent to the commission of crimes on its jurisdiction. We believe that the procedures at the IACC should be less complex and protracted, that a pre-trial chamber would not be necessary, that the number of judges on active remuneration services should depend on the caseload of the court, and that fines imposed can be used to defray the cost of the operation of the IACC. Another aim of the court, as you might have heard, is to be able to recover, repatriate, and/or repurpose stolen assets from kleptocrats and their enablers for the benefit of victims of grand corruption. So I just heard the last speaker speak about focusing on the victims. So for the benefit of the victims of grand corruption through orders of restitution and possibly civil suits. As stated at the beginning of my presentation, we see IACC as a court of last resort, complementing national jurisdictions in addressing crimes of corruption. To that end, we also see an international anti-corruption court as engaging in extensive capacity building. This would involve making its expert investigators, prosecutors, and judges available to provide advice and assistance to countries to improve their anti-corruption capacity. We also recognize that there are regional anti-corruption institutions and bodies, and we are prepared to work with such bodies to ensure the reduction of global corruption. We are patently aware that the ICC, in its early days, was perceived as a European court, largely investigating and prosecuting individuals from African countries. But we all acknowledge that corruption is a global problem. And the aim of an international anti-corruption court is to investigate and prosecute crimes under its jurisdiction, regardless of which country the national leader is from. And I see that my friend quoted Kofi Annan, and I was going to, but I would just refer to the fact that he sees it, corruption, he said, as an evil phenomenon that is found in all countries, big and small, rich and poor, but it is in the developing world that its effects are most destructive. Corruption hurts the poor disproportionately by diverting funds intended for development, undermining a government's ability to provide basic services, feeding inequality and injustice, and discouraging foreign aid and investment. Corruption is a key element in economic underperformance and a major obstacle to poverty alleviation and development. So I adopt the words of Kofi Annan. Now, I'm sure others might have faced the same attitude of many persons when they announced that they were part of this group of international experts to form an international anti-corruption court. There are many naysayers, people who don't believe that it is possible. My response to them is no one ever thought that there would be an international military court in 1945 and 1946. And I'm sure no one ever believed that there would be a permanent international criminal court formed from the 1st of July, 2002. So why not an international anti-corruption court? We are aware that the journey might be long, but where there's a will, there's a will. Where there's a will, there's a way. So I totally endorse the creation of an international anti-corruption court. And I feel that a lot has been achieved since the idea came about from the working together and our in-person interaction from August last year up until this month, and it will continue. We see a momentum building, and we invite many people to get involved and make your comments to us so that you can assist us in ensuring that we have thought of everything possible to ensure that this court works. Thank you very much.
Thank you very much, Justice Wilson, for this amazing detailed description of how IACC would hold kleptocrats, bribe payers, and money launderers accountable for grant corruption, and also base this on the experience of the creation of Rome Statute as well as the ICC. We now turn to our next distinguished panelist, Allan, who is a former Canadian Minister of Justice and Attorney General, former ambassador to the UN, and president emeritus and professor of law at the University of Ottawa. He is now a member of the World Refugee and Migration Council and is also a contributor to the experts group working on the draft IACC treaty. In the latter capacity, he has been working on the concept for a civil chamber at the IACC, and would love to hear more about the added value of that a civil chamber could have at IACC. Mr. Rock.
Thank you, and it's a privilege to be part of a distinguished panel on such a vital subject in such a prestigious forum. I will address the civil chamber, and in doing so, let me begin with the fundamental purpose of the International Anti-Corruption Court. Obviously, it's to prosecute those who are guilty of corruption crimes for the purpose of achieving enforcement, accountability, and deterrence. It's also for the purpose of identifying purloined or looted assets and dealing with them in accordance with what is just and equitable. In many cases, that will mean returning the looted money back to the country from which it was stolen corruptly. But given the massive amounts of money that are purloined every year globally, it's not reasonable to expect that through criminal prosecution, it'll be possible to recover all of the assets that have been taken. In fact, even the most efficient and effective criminal prosecution in the International Anti-Corruption Court will surely address only a small fraction of the amount that's stolen around the world. It simply won't have the resources to do more than that, no matter how well it is organized or administered. So the restitutive function of the court, the function of making restitution for the stolen money, will be very limited by the number of criminal cases brought before it and the amounts involved in those alleged crimes. So how to deal with asset recovery more broadly, how to deal with the billions and billions in looted assets identified as corrupt and frozen by governments around the world, but not connected to crimes before the IACC. Well, unless we provide for an orderly and transparent way of determining the disposition for these stolen funds, there will remain unaddressed a governance gap. And one way to address that gap is to create in a single international court two separate chambers, one for the prosecution of those individuals who commit crimes of grand corruption, and the second to oversee and facilitate through a civil procedure the forfeiture, return, and in appropriate cases, repurposing of funds and physical assets acquired through corruption. You know, the way that these matters are handled today under current law and practice is highly variable. Governments deal with looted assets and sometimes competing claims to those assets through mutual legal assistance arrangements. These are instances of what are called non-corruption-based forfeiture. So governments between themselves try to work out whether the monies were stolen, whether they should be returned, and if so, on what terms. And some governments are slow to act to address the disposition of frozen or looted assets, a lethargy that the availability of a civil chamber might help to dispel. Now, UNCAC provides for resort to mediation through the Permanent Court of Arbitration, or eventually to the International Court of Justice to resolve disputes that arise between states in the context of corruption. But the Permanent Court of Arbitration is overworked. The International Court of Justice is painfully slow in its deliberations. And so the governance gap remains very large and very troublesome. Governments and their officials are left informally to do the best they can to achieve rough justice when it comes to the recovery of stolen assets. The civil chamber of the IACC could receive, consider, and determine competing claims, clarify contested facts, and assist the states and the parties involved by providing clear, consistent, and authoritative rulings with respect to the disposition of looted funds. The civil chamber would be available to states parties to the treaty or any other state that agreed to subject itself to the jurisdiction of the civil court, opting in on an ad hoc basis for the purpose of determining a given issue. So in short, the civil chamber of the IACC could perform an important role in asset recovery. And as we work on institution building by drafting the treaty to create the IACC, strengthening the global anti-corruption framework, we can design mechanisms and processes that go beyond criminal prosecution, focusing on the proceeds as well as the perpetrators, on civil remedies as well as criminal prosecution, on restitution as well as punishment. And in doing so, we can meet a crucial need and respond to the calls emerging from many quarters for an institutional mechanism to assist states and all interested parties in achieving asset recovery. The civil chamber of the IACC would provide a channel for claimant states to approach holding states with evidence that assets on their territory or under their jurisdiction are the proceeds of corruption and should be returned to or repurposed for the benefit of the requesting state. It's worth noting that the deliberations and proceedings of the civil chamber would be based on the lower civil standard of proof, namely the balance of probabilities, rather than the higher standard, which is appropriate in the criminal context of beyond a reasonable doubt. So what would the civil chamber do? It would be tasked with assessing the legal and factual basis of a request for the liquidation, forfeiture, and return of stolen assets. It would make binding determinations in relation to those issues. It would order the transfer of financial assets, the liquidation of physical assets, and holding funds in escrow pending the resolution of a request for restitution. It would make orders of confiscation and forfeiture if a requested or requesting state lacks the capacity or willingness to do so. It would receive submissions on the proposed disposition of assets, identifying effective, trustworthy, and equitable channels for their return. It would resolve disputes between and among parties concerning the recovery of assets. It would make orders, including on equitable and lawful distribution of assets that are binding on all parties. Now, as between them, the civil chamber would have primacy over the criminal chamber would have primacy over the civil chamber if ever there were to be any situations where the possibility of a conflict between them might arise. After all, the rights of the accused person in the criminal chamber would have to remain paramount, and both treaty provisions and the court's procedure would have to be designed to ensure that proceedings in the civil chamber do not prejudice those in the criminal chamber. In some instances, for example, that might mean that the civil chamber's proceedings are stayed until the criminal prosecution has been completed. So in summary, I suggest that the guiding principles of the civil chamber would be these. It would have the mandate and the authority to assist in the resolution of disputes between states concerning the return of looted assets. Its jurisdiction would be based on the principles of reciprocity and consent, while its proceedings would be predicated on accessibility, independence, procedural simplicity, and efficiency. The jurisdiction of the civil chamber could be invoked by states parties to the treaty that creates the IACC, as well as any other state that accepts the jurisdiction of the court on an ad hoc basis for the purpose of resolving a given dispute. The court will be empowered to declare and determine the rights and entitlement of the parties in relation to the matters in issue, including any property or assets that could be in dispute. It could order the return of assets to the applicant state. In the alternative, where the court concludes on the evidence that the return of the assets to the applicant state is not feasible or advisable, the court could order the disposition of the assets in question or any portion thereof in a manner intended to achieve a fair and just result in all the circumstances, including the payment of the monies to third parties on such terms and conditions as the court might direct. Applicants in the civil chamber of the IACC could seek the opinion, advice, and direction of the court with respect to matters in issue between them and the state that holds the money. They could seek injunctive or mandatory or other interim relief, including an order requiring payment into court in the period until the final disposition of the court of the issues in the proceeding. They could seek declaratory relief, by which the court would declare the rights and entitlement of the parties in relation to the property in issue, as well as directions on its disposition and appropriate methods of disbursement. It could make an order requiring the return from one party to another of the contested assets on such terms and conditions as may be just. It would make an award of interest or other relief, including costs, to compensate the applicant for any loss suffered. So that is the overall purpose of a civil chamber, to recognize the reality that when it comes to corruption, it's important, of course, it's vital to prosecute those who are criminally responsible for the corrupt acts. But it's also both important and highly useful for the international community to have an independent, impartial, and expert institution available to it to resolve disputes between the country from whom the money was stolen and the country where it is resting in a bank account, often frozen. To anticipate and deal with disputes between those two different states and all of the other circumstances that can arise, having a civil chamber which has the respect of the international community, independent and impartial judges, would go a long way toward making this a better world. Now, there are unresolved issues I'll touch upon just briefly. It was mentioned earlier that for the purpose of victims, ought we to have some form of class action proceedings available in the civil chambers so that those who suffered as a result of the corruption can seek relief in that forum? It's an unresolved question which deserves to be discussed. What about the cost of maintaining assets, real property or yachts or airplanes in the interim until the court has made a decision? That too has to be looked at. So there are outstanding questions, but the basic concept is one that the drafting and the treaty committee agreed last summer is worth embracing. And we are now, through a subcommittee, preparing draft provisions in the treaty that will lay the foundation for the chamber that I've described. Thank you, and I look forward to a discussion.
Thank you very much, Mr. Rock. We really appreciate this interesting description of how IACC civil chamber can work in practice, and we are excited to see it actually happening. Now it's time for a Q&A session, and we would appreciate everyone to use this opportunity to ask everything that they are interested in. And before that, I give the floor to Judge Wolf to reflect on everything that was said.
Thank you very much. I said at the outset that it was gratifying not to be a main speaker in a discussion of the International Anti-Corruption Court. I can say that now with even more conviction for reasons that should be clear to you. The speakers today have shown you the quality of experience, expertise, and passionate eloquence of people who not only say they support establishment of the International Anti-Corruption Court, but are devoting their time and exceptional talents to making it a reality. I'd like to make two quick points that might amplify themes that we've heard and give you some information that hasn't been mentioned Yeah, it's very important, as I learned in prosecuting corrupt public officials in the United States, to understand and be able to communicate that corruption is not a victimless crime. It's just not money that disappears. Real human beings suffer from it. Evan particularly personifies this. He was tortured for combating corruption. But he also mentioned that in Zimbabwe, while $15 billion in diamond revenues disappeared, the country was still struggling. People of the country were still suffering from diseases like cholera and typhoid that are easily extinguishable. It echoes something that I frequently pointed to Angola, who had a president, Dos Santos, for 38 years, who made his daughter, Isabel, the richest woman in Africa. She was estimated to be worth $2 billion by the time she was 30, and flew in her pals from around the world to celebrate her birthday with bottles of champagne that cost $1,000 each, while at the same time, Angola had the highest percentage of children who didn't live to the age of 5 of any country in the world. Not because there wasn't money to provide medical care, but because it was led for decades by a kleptocrat who was not dedicated to serving his citizens, but to enriching his family and himself. Indeed, sometimes I wonder, sometimes people ask me, why at the age of 77 am I doing this? The poet Keats wrote in Fall of Hyperion about some people who feel the agony of the world. And I know that there are real victims, and have had the good fortune over the course of my career to get in a position where I can try to do something about it. And I hope you'll be inspired by the presentations you've heard today to feel the same. But there is a need to focus on it and not lose sight of the interests of the victims. With regard to a civil chamber, one way to help the victims, this was in my original Brookings article in 2014, it's something that's recurring, is to have a counterpart of the United States False Claims Act, which lets private whistleblowers with confidential information bring suits in the name of the United States. If the Justice Department takes it over and settles or wins a case, the whistleblower gets a good percentage. If the Justice Department doesn't take it over, the private whistleblower prosecutes it to a settlement or conviction, they get much more money. And this has recovered billions of dollars for the United States Treasury in the last several years. And the International Anti-Corruption Court would be a place where investigative journalists like the International Consortium of Investigative Journalists, the Panama Papers and others, and brave whistleblowers could have the evidence that they develop with such difficulty and often at such risk to themselves used in a prosecution, an effective prosecution. But the critical thing, and this picks up on a word that Allan Rock mentioned, I think the greatest benefit to victims will be in the deterrent value of having successful prosecutions of kleptocrats in the International Anti-Corruption Court. Fundamental premise of criminal law is that the credible threat of serious sanctions, punishment, will deter criminal conduct. And right now, there is no credible threat that kleptocrats will be prosecuted. Stealing this money is a crime of calculation. It's not a war crime or rooted in ethnic animosities. It's somebody calculating there's huge amounts of money there, as it was with COVID money and is now with climate money. I can steal it, nothing will happen. Why not? But I mentioned Dos Santos previously. He was president for 38 years. When he left, one of the last things he did is grant immunity from prosecution to his family and himself, because it shows that these kleptocrats are worried about getting prosecuted and punished for their crimes. You heard amplification or reiteration of a point I made at the outset, that the grand corruption doesn't thrive because of a lack of laws. 185 UN members are parties to the UN Convention Against Corruption. And almost all of them have the required laws prohibiting bribery and misappropriation of national resources, money laundering. But not only are those laws not enforced in countries ruled by kleptocrats, but as Transparency International and others have repeatedly found, those responsible for administering the UNCAC have paid much too much attention, and the world has paid much too much attention to whether countries have the right laws on the books and far too little on whether they're actually enforced. The IACC would give integrity to the promises of the UNCAC, that there will be criminal consequences for kleptocrats and their enablers who violate the required laws. The IACC would have expert investigators who could track and trace the money, and it would have, you heard this mentioned, territorial jurisdiction. This is very important because one of the criticisms of the court has been, well, countries ruled by kleptocrats won't join the court. That's true. As long as Putin's president of Russia, Russia won't join this court. They don't have to, because you also heard that it's axiomatic that these kleptocrats don't want to keep their ill-gotten gains in their own countries. They want to launder them, get it to attractive destinations, Paris, the United States, New York, Palm Springs, Miami, and also significantly London. So here's how the IACC could end up prosecuting Putin. The International Consortium of Investigative Journalists, the Panama Papers, provided what I would say as a judge is overwhelming evidence that Putin has laundered hundreds of millions and more into and through Switzerland. Let's say some of that money ends up in London. As I'll mention in a moment, the UK is very likely by the end of the year to be a leading supporter of the International Anti-Corruption Court. It is endorsed and strongly supported by the Labour Party and its shadow foreign minister, likely foreign minister, David Lammy, who was written up in the New York Times this Sunday. And the current government is considering whether to get behind it. Let's say some of that laundered money through Switzerland that Putin had is in London. He wants to have property near his oligarch pals, who are all over London. You can get on a bus and they'll give you a tour of the oligarchs' properties. If the UK joins the International Anti-Corruption Court, but for geopolitical reasons or others, doesn't want to prosecute Putin, he could be prosecuted in the International Anti-Corruption Court under the concept of complementarity. Until recently, the most common criticism of the International Anti-Corruption Court has been, this is a compelling idea, but it's impossible politically to create. That's been muted lately. And right now, 325 world leaders, including 50 former presidents and prime ministers, 2 current presidents, 33 Nobel laureates have called for creation of the court. The European Parliament has called for creation of the court. Triple I's major partner, the Netherlands, is not only a strong supporter, it's part of the official foreign policy of Canada, and other countries have publicly expressed support for it. Colombia, Ecuador, Nigeria, Moldova, and many others, particularly in Africa, have privately, and hopefully soon will publicly express support for creation of the court. And you heard from Maria that there is now this group of 60 international criminal law experts, judges, prosecutors, defense lawyers, scholars, working on a model treaty that should be available by this fall to discuss with countries that are interested, NGOs, and other experts. So a lot of progress is being made. There's a lot more that needs to be made. But Nelson, I'm almost always the oldest person in the room when the court is discussed. I'm old enough to have seen the fall of the Soviet Union, which seemed like it would be immortal, and the collapse of apartheid in South Africa. Nelson Mandela used to say, it's always impossible until it happens. And particularly, well, as more experienced and expert people get passionately committed to this, the progress I expect will accelerate. But especially important is you young people. This continues to be a long-range proposition, but a marathon, not a sprint. But you're the people who can make the decisive difference. So that's why I got on the train this morning in Boston, and very happy to be here at Fordham Law School to participate in this really excellent program. Thank you.
Thank you very much, Judge Wolf. This is a part of the puzzle, young people's initiatives, and in this case, I represent Young Leaders Network and also Fordham Law School, and we really appreciate you being here and supporting us, and all of our speakers joining remotely. I think we have a couple of minutes to potentially ask one or two questions, and I see in the room there are people who want to. Yes, Helen.
Okay, so quickly because I have to get ready to go. I mean, any of the panelists can ask, but I'm asking particularly to Justice Wilson and Pastor.
Helen?
Oh, sorry. Sorry, my name is Helen Bonero. I'm a second-year law student at Fordham Law School. Thank you so much for coming again today. I'm just going to quickly ask my question. Any of the panelists can answer, but especially particularly to Justice Wilson and Pastor Mawarire. Like, what do you think about people from particular countries prosecuting their own? Because we don't want to create another issue that people have concerns over the ICC or the International Criminal Court, where they feel like, especially particularly African countries, that they're discriminating against them and penalizing those leaders or any of the nationals there. So I just want to know, like, do you prefer anyone prosecuting these leaders under the anti-corruption court, or would you rather their own? Because that can also pose safety risks for their own in general. So I just want to hear your thoughts on that.
So if I understand your question correctly, you want to know if persons from a particular country should prosecute their own.
Yeah.
Is that it?
Yeah, like for example, like Nigeria, because I'm from Nigeria. So if somebody from that country, prosecute their own as opposed to somebody else, like, what do you think about that?
Well, a general principle in courts, I mean, I was a high court judge in the criminal jurisdiction as well, is you always want to ensure that the trial is fair and it's not biased, and there is no potential perception that you will be siding with one side or the other. So if there's any sort of conflict, so it's an issue that we would need to address closely. Prosecuting someone from my own country, you want to know I wouldn't advise it. I would want to ensure from all parties that they feel that they're getting the fair trial. So I think judges have to be carefully chosen. And I don't think a judge from the same country should in fact, I mean, I know the ICJ is a different situation, but we're dealing about criminal matters now. So it must be raised with the court, and everyone involved must feel that the trial will be fair, whoever is the prosecutor in that particular trial. But conflict of interest is always an issue that we need to speak about and disclose any sort of interest or the appearances. So that, yeah, that's my response.
I agree with that. Could I just add that, in a perfect world, countries would prosecute crooks among them in their own countries, especially leaders. It's outrageous that someone would lead a country and abuse the position of trust by stealing from the treasury. Trouble is, as Judge Wolf has pointed out, in too many of these countries, the person stealing the money also controls the police and the courts. So it's not going to be a prosecution. The value of an international anti-corruption court is that if it has jurisdiction in the case, it's not affected by the local corruption, the corrupt police, the corrupt courts. It stands apart from all of that. It stands for the rule of law. It stands for enforcement despite local conditions. And that's the value of the international institution. So yes, there'll be people complaining, oh, we should have these prosecutions in the country in particular, whether it's Nigeria or South Africa or Chile. Of course, that'd be ideal, but it ain't gonna happen because in too many of these countries, the very prosecutorial function is under the control of the crooks. So you need that independent international tribunal to make it happen.
Thank you very much, Mr. Rock. And I will give two people option to ask questions, and probably you can decide how you answer.
Good afternoon. I would like to thank you all for the speeches. I'm Emma Chikongo. I'm in my last year of master's degree, scholarship majoring in international criminal law. I'm currently writing my master's thesis on cooperation accountability towards international crimes by taking the American land. And my first question would be for Evan Mawarire. Sorry for the pronunciation. So you just mentioned that 12 million people mobilized in order to say that it was enough. And I would like to know if you think that corruption can only be stopped by the rise of the population within the country. My second question would be for all the panel. I feel that there is a big missing in this conversation, which are cooperation and multinationals. And you quickly, one of the honorable judge, I'm sorry, I'm missing the name, Justice Maria Wilson, you mentioned that the goal of the IACC was to prosecute nationals and kleptocrats, but I feel that, especially originally I'm from Congo, and I feel that corporations are taking a huge part, but when you start to analyze them, there is this issue of parent companies, subsidiaries, what is the control over the subsidiaries or the supply chains. We can appreciate that there is a rise of the due diligence principle in Europe, in France, in the UK, and I would love to hear from all of you your opinion, and also the opinion of the judge from Boston. Because
I think we have limited time. I can do the following. This court is intended to focus on political corruption, not corruption in the private sector, but corporations, beings who act for. This court is intended to focus on political corruption, not corruption exclusively in the private sector. But corporations and the human beings who act for corporations, because a corporation is a fiction, the human beings who act for it could be prosecuted in the International Anti-Corruption Court. If a corporation pays a bribe to some official within the jurisdiction of the court, say the leader of the Congo, that corporation could be prosecuted. And this is actually the way criminal cases are frequently made. This was my experience. You get the individual who paid the bribe on behalf of a corporation often, threatened with prosecution or prosecuted. And then that individual, after they're convicted or before, because they hope to get a lesser sentence, gives you evidence that permits you to get the high-level official. So this would be a means of corporate responsibility for the corporation's contribution to public political corruption, but not to something that's exclusively private.
Let me go ahead and answer the question that you asked about citizens. The thing that I came to realize is that citizens have a crucial role to play, or a critical role to play, when it comes to triggering the mechanisms in their own country that are supposed to curb corruption. And so take, for example, Zimbabwe. The Constitution of Zimbabwe gives the Zimbabwean citizens the right to challenge or support government policy. It gives them the right to ask questions about certain things that the government is doing, or certain activities that are happening. And this can happen through direct challenging, through protest or the presentation of petitions. This can happen through their elected officials in parliament. These officials who are members of parliament who then hold a government to account, individuals to account. They ask questions about what the citizenry is asking about. So that's level one of the role that citizens play, and why it's important for citizens to always be involved, or at least to be aware of how to seek recourse to justice concerning corruption. Now, they may not get an answer in their own country. They may not see justice in their own country, but it is vitally important that they take the step to ask the question, or they take the step to seek justice for that. It must be recorded that there was an attempt by citizens to get answers, to hold them accountable. Now, you would have heard, I think it was Ambassador Allan Rock who mentioned that the judicial systems are run by crooks and bought off by crooks, and that's true. That's what we've seen in Zimbabwe. So in this case, then, my hope is that citizens, through representative organizations that could be part of civic society, can then also approach the International Anti-Corruption Court, because they have failed to find help at home. But where they have evidence, where there has been thorough investigation, my hope is that they are able to then come through to that court as well and make representation. So yes, absolutely, citizens can help to curb corruption. They can sound the alarm, and they can trigger certain processes, which I believe that when public officials are aware that their citizens are aware of the process and of mechanisms, I think that makes them think twice, or makes them kind of slow down in their approach, or to think twice about the crime that they would be wanting to commit for corruption. I hope that answers your question.
Thank you very much. There is one question left that I will be taking, and probably we can answer that shortly.
Thank you so much, and thank you all for coming today. My name is Caroline Mawarire, and I have a question about the plaintiff side in this civil court. You mentioned briefly, I think Mr. Brock, class actions, and I was wondering, like, coming to the court, you have prosecutors who recover these ill-gotten funds, but then distributing them to the victims. Technically, in this situation, is the country coming to the court? Who's going to distribute the funds, and would a private class action be a better method of getting it directly to the citizens? Thank you.
Mr. Rock, I think we can hear you.
The sound is sort of muffled up here in Canada, so I'm going to take a guess at the question that had to do with class actions. And the question was whether class actions could provide an effective remedy for individuals who suffered loss as a result of corruption. I mentioned that this is an unsettled question. It's not something really that we've discussed at the table among those who are drafting the treaty. It was mentioned at our last subcommittee meeting in early April, but it hasn't been resolved. But if we're looking for ways to provide practical remedies for those who are the victims of corruption, the people whose healthcare, whose infrastructure, whose education, whose social services have been non-existent because the money to fund them has been taken by the crook, if those individuals want to seek redress, it seems to me that we should explore the possibility of them having status when the court decides what to do with the money that's been stolen. And the concept of a class action on behalf of all of those who suffered identical loss in the class, I think might be, as it is in litigation generally, an efficient way of achieving justice, as well as modifying behavior, which is another one of the purposes of a class action.
Thank you. Thank you very much, Mr. Rock. If nobody wants to express additional remarks, I will conclude with this. I want to thank our partners, Leitner Center of International Law and Justice of Fordham Law School Executive Director Elizabeth Vickery for helping us a lot throughout the year, as well as Integrity International Initiatives, specifically Managing Director Ian Lynch, who was one of the key figures in organizing today's event, and thank you very much. And Citizens for Global Solutions to help us very much logistically, Dria Bergman, Sarah Tisho, thank you for your support, we appreciate that. And thank you FILA board members who helped me a lot organizing today's event. This is our last event. Fordham International Law Association has concluded its program of the year. After establishing the association in the beginning of the year, we held more than 20 programs, having more than 60 guests, and we are honored to have our semester concluding with amazing panel discussion, amazing speakers today, and Judge who is present here and contributing to this discussion in person, as well as our virtual speakers. Thank you very much, and we hope to see you at Fordham again. Thank you.